What happens to inheritance in common law intestacy? Imagine losing a loved one without leaving a will. What happens to their assets? If you are curious about how estate laws work when someone dies without a will in a common law state, stay tuned. When a person passes away without a will, their estate goes through a legal process called probate. During probate, the court looks at the state's inheritance laws to decide who gets what. Unlike community property states where spouses automatically share all assets, common law states follow a different set of rules. These rules create a specific order of who inherits the estate. Usually, the surviving spouse gets the largest share, but it depends on who else is still alive. If there are no children or parents, the spouse often inherits everything. If children are present, the estate is split between the spouse and children based on certain percentages. Some states give the spouse 1/3 of the estate and the children the remaining 2/3. Other states might divide it differently. If there is no spouse or children, then the estate goes to surviving parents. If no parents are alive, it moves to siblings or more distant relatives like grandparents, aunts, uncles, or cousins. When no relatives can be found, the estate is transferred to the state through a process called a escheat. Every state has its own laws about intestate succession, so the exact distribution can vary quite a bit. For example, in Pennsylvania, if a person leaves a spouse and children, the distribution depends on whether the children are also children of the spouse. If all children are shared, the spouse gets everything. But if there are children from previous relationships, the division becomes more complicated. When someone dies without a will, their estate must go through probate court. The court appoints an administrator to handle the estate, pay debts, funeral expenses, taxes, and medical bills first. Only after these obligations are settled does the estate get divided among heirs. It is important to know that in common law states, stepchildren, foster children, and in married partners usually do not inherit unless specific legal steps are taken. Full siblings and half-siblings are treated equally, and adopted children are generally considered the same as biological children. If a child is born after the person's death but before the estate is settled, they are also entitled to inherit. Understanding these rules highlights why estate planning is so important. If someone dies without a will, the state's rules decide who inherits and in what amounts. This might not match what the person wanted. For example, a surviving spouse might not get everything, and children from different relationships could inherit equal shares regardless of the deceased wishes. And married partners often get nothing unless they have legally arranged for inheritance. That is why creating a will or trust is highly recommended. These documents let you choose exactly who gets your assets and how much they receive. Without them, the laws of intestate succession take over, which might not reflected your family situation or personal wishes. Planning ahead with legal documents helps ensure your estate goes to the people you care about most, just as you want.